When spouses in a community property state divorce, their property is divided into separate and community estates. Each spouse keeps their own separate estate, and the community is distributed between them. So it's critically important how property is categorized, as an unlucky wife learned in Beam versus Bank of America. Mary and Walter Beam were married for 29 years. Before their marriage and during its early years, Walter inherited approximately $1.6 million in cash and securities. As an inheritance, this was Walter's separate estate. Walter wasn't employed during the marriage. Instead, he managed his investments, trading stocks and bonds and participating in real estate ventures. Mary was a housewife and cared for the Beamses' children. When the parties filed for divorce, Walter's separate estate had increased in value to approximately $1.8 million. Evidence at trial showed that the Beamses' only source of income during the marriage came from Walter's estate. Evidence also established that if Walter had earned a professional investment manager's salary, he would have received an annual amount less than the family's annual expenses. To calculate the community estate, the trial court applied the legal interest rate to compute a reasonable rate of return for Walter's separate estate. If Walter's investments had grown at this rate, his estate would have been worth over $4 million when the parties divorced. Because the estate's value, combined with the marital expenses over the years, was less than this amount, the trial court ruled that the entire increase was attributable to ordinary economic factors and not Walter's efforts. Therefore, there was no community property except for a promissory note for several $1,000s, which Walter agreed to give to Mary. Mary appealed to the California Supreme Court. Before the court heard the appeal, Mary died, and her executor, Bank of America, was substituted as a party.